admin. So welcome everyone to the 2025 Labor Law Update. Today we are so happy to be sponsored by the Workforce Development Board of Alameda County. My name is Anna Manzano. I'm the Digital Media and Event Strategist here at the California Employers Association. And we're so happy that you're joining us today. Before we get into today's training, a couple details to go over with you. So as you see, your audio will be muted for today's presentation, but there are going to be lots of opportunities to engage during the training. If one of those ways is by asking questions, you can put those into the chat box at any time, and we will try to address them as we go. Juliana is going to be delivering the content today, and I will be closely watching that chat box to make sure if you have any technical difficulties or any questions that we get those over to her. Handouts for this training, those were sent out in Friday's reminder email. I know we had a few registrations over the long holiday weekend. So what I'm also going to do is to drop that PDF file into the chat. So once I'm in a moment, I will drop that PDF into the chat. You'll see the link and the icon pop up. Once you click it, it'll just download locally to your drive, but please ping me in the chat if you have any trouble accessing that PDF, and I'll make sure that you get it. We do have a recording. So since Alameda so generously sponsored today, what I do is I send the recording file to them. And then once they make it available for playback, they will reach out to all of you and let you know that it is available to be accessed. Last but not least, we do have a survey. It is a very brief 5-question survey. Most of them are multiple choice, so it generally takes about a minute to complete. But we really encourage everyone to click through at the very end. Because the feedback that you share with us, we then share with our partners over at Alameda County. And together, we just collectively try to make sure that we are meeting and hopefully exceeding your expectations with both trainings like this, as well as the entire suite of resources available to employers like yourself. So if you could either scan the QR code or click through to the link at the end, we would greatly appreciate that support. So again, our training is brought to you today by Alameda County. I've said it a couple times now. Today in the chat, we will be joined by Carmelo and Darlene, who are on their team. They are going to place their contact information in the chat shortly. They may have already, they already did so. So make sure that you take that information down and connect with them in the chat if you have any questions. And then as I kick it over to Juliana here, she'll be able to speak to some information about the hotline. So as I mentioned, today we have Juliana Gabriel, our Vice President of Human Resources, who will be taking us through, and it is all yours, Gigi.
Thank you, Anna. Welcome, everyone. We're very excited to have you join us. Anna's right. We have a lot to cover in this 2025 labor law update, so I hope you have a nice warm beverage of choice, whether that's coffee or tea, to warm you up on this chilly morning and get you through this training. Again, a big thanks to the Alameda County Workforce Development Board for sponsoring. And I also want to remind you that they also provide a complimentary HR hotline for employers that's serviced by California Employers Association. So if you've never used this before, how it works is you can call in Monday through Friday, 8 to 5 to that hotline number there, and you will always get a live HR advisor to help you out with any sort of HR questions that you might have. So whether it's on one of the new laws, or maybe you want to talk about a paid sick leave policy or vacation policy, or maybe you have wage and hour questions, employee relations issues, you name it, you can call into the hotline and we will provide you guidance and resources. So if you have a question that maybe pops into your head after you attend this training today and you say, oh, I wish I would have asked that question during the training, you can also use the hotline for that. So we encourage you to use it if you have not done so before. Now, who is California Employers Association, or CEA? We are an HR consulting company. We have members located throughout the state of California and beyond, and our goal is to provide you peace of mind with your HR solutions. So if you are looking for a little bit more support beyond that hotline, if you want access to HR forms and policies and fact sheets, or help with customizing an employee handbook, or having someone come on site, conduct an HR audit for you, that's where CEA can come in. You can join us as a member. We have our contact information below there. So that's our website, employers.org, and you can always just give us a call at our main number there if you would like more information on our services and offerings. I do want to note that this presentation today is for educational purposes only and should not be relied upon as legal advice. So although we're going over the new laws for 2025, we're going over generally applicable information, best practices, but if there's an issue of legal significance that comes up for you, For example, maybe you're concerned you haven't paid someone properly or you've misclassified them. Really important that you consult your own attorney about that, get some attorney-client privileged advice. CEA is not a law firm. We cannot give you advice, legal advice. But as Anna mentioned, you're more than welcome to ask us questions about the content today. You can go ahead and put that in the chat box, and I'll be monitoring that throughout and trying to make sure to answer those questions live. Make sure to get to all of your questions as we go through this training today. All right, so what is on our agenda? We are going to start with our wage and hour updates. So we have, of course, wage increases that we can pretty much always expect around this time of year. And also something really important is this new PAGA reform that happened last year. If you're not familiar with what PAGA is, that's okay. We're going to explain what that is and why all California employers should be paying attention to that new law regarding how wage and hour lawsuits are going to be litigated in court going forward. We also have some new rules regarding certain independent contractors. So there's some increased protections for independent contractors. So we'll go over that new bill that happened this year. And then we're going to transition into some new employee rights. We have new laws regarding captive audience meetings. So we'll talk about what that means. You might be familiar with that if you've been in a union setting, but it's really more broad than that. This new California law is going to apply to all employers. And then we have some new clarifications regarding protected classes under our Fair Employment and Housing Act. And then also a new prohibition on what you can put in a job ad. That one's a really important one to pay attention to. Again, it's going to apply to all employers. Then we have our leaves and benefits sections. And this is not really brand new information, but just some changes to existing laws and protections that we had before regarding crime victims' rights, our paid family leave program through the EDD, and then what's known as the CalSavers retirement program if you do not offer a retirement program, such as a 401k, what you need to do there. And then we'll close out with some safety. And this is kind of, again, a recap of some big changes that happened last year with workplace violence prevention plan and heat illness prevention plan requirements. So jumping right in to wage and hour, let's start with our wage increases for 2025. For our non-exempt or hourly employees, again, this is the default in California, you are looking at a minimum wage for the state at $16.50 an hour. Alameda's is higher than that. We're going to talk about that in a minute. You also want to pay attention to local minimum wage requirements, but as far as the state of California, we are at $16.50 an hour. And the reason why we tend to see these bumps happen around January 1, there's a provision in the law that when inflation in the consumer price index exceeds a certain amount, it results in these automatic increases in the minimum wage. That's why we've seen this happen for the past few years now. You might say it seems to go up every year. That's been the reason why. And what some people don't know is that minimum wage is also going to impact what we have to pay our exempt salary employees. It's always tied to the state minimum wage. So for them to be properly classified as exempt, their salary needs to be at least 2 times the state's minimum wage times 80 hours a year gives you that annual rate. So that has now been bumped up for our white collar professionals, administrative, executive, and professional exemptions to $68,640 per year. And if you say, well, we have an exempt employee, but they kind of work part-time, can we prorate that amount? The answer is no. That is the absolute minimum that you have to pay in California. If you cannot sustain that in your budget, what you're going to want to do is reclassify them to a non-exempt hourly employee. Otherwise, they're going to be misclassified. In addition to that salary test, they also have to meet a duties test. So with exempt employees, there's a few hurdles that we have to overcome to properly classify them. The risks we run if we're not properly classifying them is they could come after us for unpaid overtime, missed meal and rest breaks, inaccurate wage statements. So it's really important to get this right. But like I said, the default is anybody can be non-exempt. So it's never a problem to reclassify somebody to non-exempt hourly. There's just some steps you want to make sure you take to document that properly, make that change. We have a great fact sheet for you. We have that bit.ly link that you can put into your browser that goes over how to transition an employee from exempt to non-exempt, some tips around that. As I mentioned, it's not quite that simple in California. We also have our local minimum wage requirements. Depending on the locality, they might require higher than what the local with the state's minimum wages. And so in Alameda, we are at $17 an hour, and a lot of the other cities around the Bay Area, and then also in Southern California, around LA, San Diego, you'll see a lot of these local minimum wage ordinances. And a lot of them will kick in if you are sending people, let's say, to different client sites or maybe a work conference. If somebody's working 2 hours or more in that jurisdiction, a lot of them, that's when they'll kick in, but it always comes down to the specific local ordinance. So if you do have employees that are traveling for work, you really want to pay attention to these, or if you have other worksite locations, because the local minimum wages apply depending on where that employee is physically working. A lot of employers also missed this during COVID when they sent people to go work remotely, go work from home. They didn't check, well, is their home in a locality that has their own minimum wage requirements? So also pay attention to that for your hybrid or remote workers. A lot of these local minimum wages increase on January 1, and then another good handful of them increase July 1 each year. So Alameda's just increased July 1. So we're going to want to pay attention also at the mid-year. Again, we have a great bit.ly link for you. I see Anna's already putting those links into the chat, so you can directly click on them if you need, that lists all of the current local minimum wage requirements. So you can check that for where you have workers. We also have some industry-specific wage requirements now. This is brand new. So California's wage schemes are becoming even more complex just within the past year. So we had this fast food minimum wage that went into effect on April 1st of 2024. You've probably heard about it. It increased for fast food workers the minimum wage to $20 an hour if that worker is at a fast food chain with over 60 locations nationally. So think about a lot of franchises, right? McDonald's, Starbucks. It also impacts the exempt employee salary. The DIR clarified this for us in FAQs. They said it's tied to the fast food minimum wage. So for a fast food worker to be properly classified as exempt, if they fall under this, would have to be earning $83,200 per year. Again, if you can't sustain that in your budget, you would want to reclassify them to an hourly employee. Another component of this is the Fast Food Council was created under the DIR, the enforcement authority in California, and they have the authority to recommend working conditions that could be unique to fast food, unique safety issues and other requirements, and set minimum wages each year subject to caps up until 2029 as of right now. So we want to stay tuned for that. They did not increase it for January 1, 2025, so we're still at that $20 an hour, but just be on the lookout for that each January, and we'll have to see if they have any unique rules. Another area is healthcare. So there was this goal with SB 525 for healthcare workers to eventually earn $25 an hour. And I think a big motivating factor was just what we saw a lot of our healthcare workers go through during COVID that really inspired the legislature here. There was a couple little snags with the law going into effect. It was supposed to go into effect a couple different times, and then it was delayed by the legislature. They wanted to kind of clean things up and work things out. But it did finally go into effect in October of 2024, and it applies to almost all types of healthcare facilities. So from hospitals to skilled nursing facilities, a lot of physician groups and clinics. And the minimum wage you're subject to depends on how your specific facility is classified. So there's different minimum wages depending on the type of healthcare employer that you work for. So right now they range from $18 an hour is the low end to $23 an hour at the high end. And there are expected increases coming again June 1. So again, mid-year is going to be a time we want to be on the lookout. Their test for someone to qualify as exempt here is even more complicated. So employees, and to be properly classified as exempt, must be paid 1.5 times their applicable healthcare minimum wage, or 2 times California's minimum wage, whichever is greater. So anytime that healthcare minimum wage goes up or California's minimum wage goes up, the employer is going to need to do a calculation to see what is the greater of those two. And that is what employees would need to be paid to be classified as exempt. All right, so moving on from all of our different wages in California, it's also at this time of year that we like to remind employers about personal vehicle usage and what we should be reimbursing for that. So as a reminder, under the California Labor Code Section 2802, As employers, we have to reimburse all reasonable and necessary business expenses. So all of the costs of doing business fall on the employer. And that is for both exempt and non-exempt employees. We have to take that on as the employer. One of those things is when somebody is using their personal vehicle for work purposes beyond the normal commute. So maybe they commute to work, but then you're sending them to a client site, or you say, hey, go pick up lunch for the office. When they are having to engage in that business travel, we have to make sure for both exempt and non-exempt that we are reimbursing for their business mileage. Now, the default is that you use the IRS mileage rate for every business mile that is traveled. That is going to be presumed that you are sufficiently taking into account not only the cost of gas, but wear and tear on the vehicle, depreciation, maintaining insurance. So that's why this is the safest approach. And that IRS mileage rate tends to go up each year. It went up on January 1 to 70 cents a mile. So this is what we would recommend when someone is traveling using their personal vehicle for business purposes. You're reimbursing them 70 cents for every business mile that they travel. If you use some other method to reimburse and that employee brings a claim against you, then the burden is on the employer to prove that it was a sufficient reimbursement. So this is the safer approach. And then remember also for hourly employees, not only are we reimbursing them for the mileage, cost of gas and those types of things, but also for their time. So anything beyond their normal commute when they're engaging in business travel, that's compensable time, on the clock time that we also have to make sure we're accounting for. All right, so here's kind of the exciting update here, the PAGA reform that I mentioned that happened last year. So for those of you who are not familiar with what PAGA is, PAGA stands for the Private Attorneys General Act. And what it is, it's a law that allows basically employees to step into the shoes of the California Labor Commissioner and seek penalties against employers on behalf of themselves, as well as other employees for labor code violations. And that's going to typically mean wage and hour issues. So it could be, we aren't receiving sufficient meal and rest breaks, or our wage statements are inaccurate. And so these penalties can stack on top of whatever the employer already owes employees for any underlying violation. So it can get really expensive very quickly. As you can imagine, there's been criticism from employer and business groups over the years for those employers that have been hit with these PAGA lawsuits. They're very complex to defend. Employers can get hit with these types of lawsuits multiple times. And so there was going to be an attempt on the ballot to pretty much gut PAGA almost entirely, get rid of it. That's not what ended up happening. What ended up happening is that business groups and employee groups and unions came together and basically came to a deal. And that's what resulted in this new legislation last year, AB 2288 and SB 92, that went into effect on July 1st, that is going to change how these wage and hour lawsuits are litigated going forward. So they're going to be a little more employer friendly. There's more opportunities to cure violations early on and fix issues. There was also some wins for employees, because a lot of the criticism around PAGA has been that so much of the recovery goes towards attorneys' fees and not really the employees that are reaping the benefit of that. Now, I'm not going to get into all of the ins and outs of this with you today, because it's really going to be most relevant for attorneys who are defending these types of lawsuits. But what I do want to call your attention to is these new opportunities for employers to take these reasonable steps to comply with wage and hour laws. And if you do that and you're later hit with a PAGA lawsuit, there are certain instances where you could reduce your penalties by up to 85%. So that could be thousands, maybe even tens of thousands of dollars if you're a larger employer. It can make a huge, huge impact. So what these reasonable steps are actually spelled out in the new law, what the legislature wants to see employers doing. They want to see that you're engaging in periodic payroll audits and taking action in response to results. So basically going through your payroll records and seeing, are we giving sufficient meal and rest breaks? Do we have any meal breaks that weren't taken timely or were too short or interrupted? Have we looked into what was the reason why that happened? Are we calculating overtime properly? Are we using the proper regular rate of pay? Do we have all of the required information on the wage statement? Those are the types of things that you would be looking at. And then if you find any discrepancies, following up and correcting those things early on. They also want to see that you're distributing lawful written policies, wage and hour policies. So that could look like your meal and rest break policies, for example, your clock in and clock out policies, making sure you let people know working off the clock's not permitted. Let a supervisor know if you have any time that hasn't been captured on your time card, right? Those types of things. So you want to make sure you're keeping your employee handbook up to date with those policies. Training supervisors on wage and hour compliance. So they didn't go so far as to make this a mandate like we do with harassment prevention training, but they want to see that there's some level of training for supervisors on what the wage and hour rules are, what are the specific rules for your industry. In my anecdotal experience, I don't think a lot of employers have been doing this in a formal way. It might be happening informally for supervisors on the job, but I think we are now going to see companies start to do more formalized wage and hour training. And then taking corrective action for supervisors who are not following your policies. So if you have supervisors who are not scheduling people for their breaks or they're interrupting them during their breaks, that you're following up with them, you're counseling or you're disciplining them, and you're making sure that that behavior stops. There's also, I want to just mention really quick, new opportunities to cure violations earlier on. So if you do receive what's known as a PAGA notice, letting you know that someone believes that you're in violation, there's ways now to cure certain violations and potentially avoid even having to go to court with those. They're very specific and very nuanced. So really the only takeaway I have here is if you get one of these PAGA notices, make sure that you consult legal counsel promptly so you can go over all of your available options and deal with it early on. Our organization does offer a wage and hour audit package to kind of self-guide the employer through going through an audit and looking over your wage and hour practices, as well as it comes with a training for HR professionals and a recorded training for supervisors. So that is available on our store at employers.org if you need some additional help with that. And another new bill that we had this year was SB 988, and this has to do with increased independent contractor protections. This does not change the test for how to properly classify someone as an independent contractor versus an employee, but it does include some additional rules that you have to meet if you're hiring certain independent contractors. So we know in California, it's already a rigorous test to be able to classify someone as an independent contractor in the first place. We have to meet what's known as the ABC test. But what this new rule is saying is even if someone's properly classified, if you're hiring an individual person, or maybe they have an organization, but they're the only employee of that organization, so it's a solo person, and you're going to be paying them $250 or more for their services, in most instances, you have to have a written contract. So you can't have just a verbal or a handshake agreement. It's going to need to include information like the name and mailing addresses of the parties, the list of services to be performed, the value of those services, how you're going to pay, when payments due. So they want it all spelled out. So that independent contractor, that solo person who doesn't maybe have as much leverage as the hiring entity, has that additional protection where they have it all spelled out in writing, what's going to be owed to them. This law also makes clear that once the work has started, the hirer can't try to wiggle out and say, well, we'll pay you on time, but only if you agree to accept less compensation than we initially agreed upon. Or you actually need to provide us more goods or services before we'll pay you, or give us more rights to your work, for example. And that independent contractor, if these things are done, could sue for retaliation, as well as the California Enforcement Agency, a prosecutor, for example, could also go after a hirer. So this is all surrounding protections for the independent contractor. Here are the current services covered. If you're hiring them to do one of these things, that is when you would have to have it in writing. So I'm not going to go through each of these. You can see it's a long list. So I would save the slides if you do hire any independent contractors for these types of functions, marketing, HR, photography, etc. All right, so let's wrap up on our wage and hour to-dos. So we're going to want to ensure that we are paying those appropriate minimum wage rates as of January 1. This is also a time that you're going to want to update what's known as the wage theft notice. So this is a free notice. It's provided by the DIR. We're supposed to provide it to all non-exempt employees at the time of hire. And then anytime that we change their rate of pay, for example, whether it's a minimum wage increase or maybe we're promoting them, we're supposed to update that notice. That notice just has some basic information about their employment, such as their rate of pay, overtime rates, paid sick leave, and those types of things. So make sure if you don't have that on file, I would recommend getting that on file for every non-exempt employee with up-to-date information. Adjust those salaries as well that we went over. I would recommend that everyone, all California employers, start implementing those reasonable steps in light of the PAGA reform. So decide who's going to be responsible for conducting those payroll audits, making sure your supervisors are trained on wage and hour. It's just a good idea in general to avoid a wage and hour lawsuit in general, but now it's going to have that extra benefit of potentially protecting you from additional penalties in a PAGA lawsuit. And then review those independent contractor arrangements. And we would recommend that you consult with legal counsel about that when you're hiring independent contractors. Really important you properly classify them. All right, so we are going to now shift gears into some new employee rights and protections. A big change that happened last year was the EEOC, that's a federal enforcement agency, updated their guidance on harassment after nearly 25 years. And they now have 77 different examples and clarification on what harassment can look like. And really, I view this document as them just kind of catching up with the times and the different nuances of what the workplace looks like now. We have remote work. We have so many different things that maybe years ago we weren't paying attention to, 25 years ago, you can imagine. So some of the key highlights here, but I would recommend that any HR professional take a look at the EEOC guidance. But they say harassment can include intrusive questions about sexual orientation, gender identity, gender transition, for example. So remember, it's not just sexual harassment. It can be based on a number of protected classes, especially in California, we have even more protected classes. Harassment of LGBTQ plus workers can include the denial of access to bathrooms consistent with their gender identity and intentional and repeated misgendering. Sexual harassment can be based on pregnancy, childbirth, and related medical conditions. So that's tracking that fairly new Pregnant Workers Fairness Act. That was a federal law. So that's just getting in alignment with that. Of course, we know harassment can occur in remote work environments. There doesn't need to be physical presence, right? It can happen online, messaging, right? And they also introduced this concept of intersectional harassment, and that is harassment based on more than one protected characteristic of an employee. So it's the unique combination of multiple protected characteristics. So one example that the EEOC provides is stereotypes about older women can be based not just on age, but also gender. It's the unique combination of those two things coming together. And someone could bring a claim that's basically says it's based on these characteristics that I hold. It's not just one or the other. California followed suit here with SB 1137 this year. They amended the Fair Employment Housing Act's definition to recognize this concept of intersectionality. What I would recommend is that you update your anti-harassment discrimination or equal employment opportunity policies to include some of this language to just clarify that. That would be my to-do here. Just noting that people are protected based on any of the protected classes or a combination of two or more protected classes. So I would just make sure you review your handbook and take a look if you want to make any updates there. SB 1100, this is the driver's license discrimination law. This one is, again, as I mentioned, a big one that you're going to want to pay attention to for all employers this year. So what it says basically is now an employer cannot require a driver's license on an advertisement, job posting, job application, or other related material unless the employer reasonably, number one, expects that driving is actually a function of the position, and two, believes that alternative transportation would not be comparable in travel time or cost. So it would not be comparable to or feasible to have someone Uber or taxi or bike, for example. And what the legislature's concern here is that if we require people to have a driver's license, we might be excluding people, certain groups that are more than qualified for the job. And it's not always necessary to have this blanket rule. So if it's just that that person needs to commute to work, we probably could not put a driver's license requirement on the job application or advertisement, because maybe they could come up with an arrangement. Maybe they have someone that can drop them off, or maybe they can take public transit. They can find a way to get to work. So we have to be careful. We need to look on a case-by-case basis based on the job. So as an example that I give at CEA, we have trainers that go out and train different employer groups. They have to be able to go all throughout California. And so they need to drive to be able to do that. California is a big state, so driving is a function of that position. And given the far distances that they travel, we would probably have an argument. It's not comparable to send them in an Uber or a taxi. It's just not going to be feasible with cost or time. But let's say we have an admin person that occasionally goes and makes deposits at the bank, and the bank is 5 minutes away. Well, in that case, maybe that admin person could bike or walk. If it's only 5 minutes away, it's not going to add that much extra time if they're doing that. And so that would be a harder argument to make, that a driver's license would be required for that position. So really important that you have someone take a look at your job postings and application materials. If you have that kind of as just a general requirement, I would take it out and add it back in on a case-by-case basis as needed, so you don't run into a potential discrimination issue under the Fair Employment and Housing Act. All right, and then SB 399, this one was a bit controversial. It's what's known as the captive audience meeting ban. And so here now, what this says is employees can decline to attend any meeting or listen to any communications regarding an employer's opinion about religious or political matters. And those things are defined very broadly. So religious could be an employer's or managers, right? Because that's the agent of the employer. Opinion about religious affiliation or practices. Political matters is even broader. It could be about elected officials, new laws, union, whether someone should unionize. So what that means is if an employer started to talk about one of those things or have a meeting, the employee would have a right to leave without any sort of threat of adverse action against them. So they can't have any employment consequences against them for that. And the employee who was working at the time of the meeting and elected not to attend would still have to be paid for that time. Now, this has already been challenged in court. There's arguments that it's not constitutional, that it's preempted by federal law. So we will have to see kind of what ultimately happens here. I would probably recommend that you're still training your supervisors and managers just in general, that they know that employees have this right if there's a discussion on religious or political matters, where the employer is giving their opinion on that. But we'll have to really see where this law ends up going, if it's going to end up being upheld. On a federal level, captive audience meetings have been permitted under the National Labor Relations Act, meaning you could, it was typically in the context of unions, that you could call employees in for a meeting, give your perspective on why maybe they shouldn't join the union, right, or what benefits you provide, that's not necessary. However, in November 2024, the National Labor Relations Board changed their rule on that, and they said mandatory captive audience meetings are unlawful. So that's the status quo right now. With a new administration, we may see that change. These things kind of tend to flip-flop back and forth with changes in administration. So there's more to be seen here with captive audience meetings. But for the California law, as I mentioned, would probably recommend making sure your managers are trained on that until we hear otherwise. Another important change is making sure that our labor law posters are up to date in our workplaces. So this is our state and federal notices that we're required to post. Again, around this time of year, a lot of the times the posters, some of them at least, will be updated. So if you have, what most employers do is they order an all-in-one labor law poster that they put up on their wall in their break room, right, or the common areas. So you want to make sure you're up to date with a 2025 poster. These were the postings that changed this year. The whistleblowers poster was updated to make sure that it clarified all rights for whistleblowers, for employees that might bring a complaint to a state agency, right? Minimum wage posting, since that went up, the minimum wage poster changed. And there's also supplemental posters, additional posters for fast food and healthcare you want to make sure you have if you're in those industries. The workers' comp poster was updated just to clarify that an employee has a right to consult an attorney regarding their workers' comp case, and that in most cases, their attorney's fees will be paid from whatever that employee's recovery is, that they don't have to necessarily come up with the money for the attorney's fees. And then the Civil Rights Department also updated their posters. So discrimination, harassment, for example, they clarified that concept of intersectionality, family care and medical leave, and PDL. So if you do need a poster, we do have them on our store at employers.org. So make sure that you have a 2025. All right, so employee rights and to-dos, what are our reminders here? As I mentioned, that EEOC guidance was updated regarding harassment. It's a good reminder that harassment prevention training in California is due every 2 years. So if you last trained your staff in 2023, that means they are coming due in 2025. Make sure you revise your handbook policies, keep them up to date regarding those protected class clarifications. Take a look at your job postings to ensure that that driver's license requirement is appropriate when you're including it. Train the supervisors on the captive audience meeting law and make sure your posters are updated for 2025. All right, so now let's talk about leave laws and benefits. We've already covered a lot of information with you. So this new law this year, AB 2499, expanded crime victims' rights when someone is a crime victim, that they can take protected leave and time off from work. But this is not really brand new. There's just been some tweaks and clarifications. So I want to first go over what was the law, what did it already require prior to January 1, 2025, and now what are going to be some of the changes that we might see. And this is for all employers, regardless of size. So we've already been required to provide time off from work for things like jury service, witness duty if someone's subpoenaed as a witness, and when someone is seeking relief for the safety of them or their child, if they're a crime victim. So, for example, someone might need to get a restraining order, right? So they have time to do that, to take time off work for that. They've always been able to use vacation and paid sick leave if the employee was a victim of domestic violence, sexual assault, or stalking. We also have been required to reasonably accommodate crime victims to ensure their safety at work. So, for example, they might say, I would like a lock on my door because I don't know if this person, maybe that there's a person in their life that they're concerned might come and try to attack them. Or I need to change my phone number. They're aware of my work number and they're starting to call it at work and they're harassing me, right? Or I might want a buddy to walk me out to my car at the end of my shift. These are the types of things we would have to make sure that we are assessing. Can we provide a reasonable accommodation? Of course, we have to maintain their confidentiality with that, not broadcast that to anybody who does not have a need to know. There's also some other laws regarding time off rights for certain judicial proceedings where the victim's rights is at issue. Those have not been changed. So those are still in the labor code. We've listed them here. Those have not been amended at all, but we're just calling your attention to how broad crime victims' rights are. All right, so what are the changes for January 1, 2025? There's a new definition of who is a crime victim. I'm going to go over it in just a minute. It's more broad now than it used to be. They've also clarified that an employee could seek a reasonable accommodation, even if they themselves wasn't the crime victim, but they had a family member who was the victim of crime. They may still have a concern for their own safety at work, and so we would have to accommodate them. We'll talk about who those covered family members are in just a minute. It's been clarified employees can use paid sick leave now for the broadened crime victim purposes and vacation if they want to. And there's also a new notice requirement. So even if you never have somebody that is a crime victim in your workplace, you are going to have to provide this notice. So it is going to need to be distributed to all new employees upon hire. So it's going to need to be part of your onboarding paperwork. This one's really interesting, to all employees annually. So this is not like one of the posters that we're having to post up. We actually have to distribute this to employees on an annual basis, this notice. And then upon request of an employee, or anytime an employee informs the employer that they or their family member was a victim of crime. Now, we don't have this new notice yet, and our obligation to provide it doesn't begin until it's issued by the Civil Rights Department, and they have until July 1. So we'll be on the lookout for this. You can subscribe to our blog at employers.org. That is free. We're always looking out for these types of updates. But once the CRD provides it, then we're going to trigger these obligations to provide this notice. Also, this is just kind of a smaller issue, but these rules used to be under the labor code. They're now under the Fair Employment and Housing Act, meaning that the Civil Rights Department will have enforcement authority over crime victims' rights. We may see increased enforcement here. Now, who is a victim? It's an individual against whom a qualifying act of violence has been committed, and that can still include domestic violence, sexual assault, and stalking, but also acts, conducts, or patterns of conduct that include bodily injury or death, the use of a firearm or other dangerous weapon, or threatening to use force or cause physical injury or death. So as you can see, that's really, really broad what it could encompass. The covered family members under this new law are the same that are under our California our family and medical leave in California, and that is child, parent, grandparent, grandchild, sibling, spouse, as well as designated person. So someone that employee designates that is equivalent to a familial relationship. Now, for smaller employers under 25, not a lot has really changed, just those definitions that we went over. It's a little broader now, right? But if you have 25 or more employees, there's going to be more that has changed, and really important to make sure that your handbook policies are tracking this. So there's already been expanded rights if you have 25 or more employees that employees can take time off to seek medical or mental health care. So not just leave for court, but for these other needs, victim services, safety planning. So that's still the case. But now they've added additional reasons here that someone could take time off. So someone might need to seek relocation to secure a new residence or school for their child. So you can imagine, let's say, if someone isn't victim of domestic violence, maybe they need to get out of their home, it's not safe, so they need to find a new house, new school, right? They could take time off for that. Or providing care to a family member who's recovering from being a crime victim, or providing childcare or care to dependent adult to ensure their safety. Now, it has been clarified, you can limit the total combined leave for all reasons to 12 weeks. And if someone is eligible for family and medical leave, that leave can run concurrently, meaning all at the same time. So it's not 12 weeks and then another 12 weeks of family and medical leave. It all happen at the same time. And for certain issues, you can limit it even further. So if the employee's family member is the victim, as long as they were not deceased as a result, you could limit the time to 10 days total. So if it's the family member, 10 days as opposed to 12 weeks. And when it's being used for that relocation or finding a new school, you can limit the time to 5 days for that particular reason. So again, important to update your employee handbook on this if you have 25 or more employees. All right, moving right along here to paid family leave. What paid family leave is, it's a program through our Employment Development Department, the EDD, when typically it's used when someone is off work and they are needing to care for a family member with a serious health condition, or a lot of the times it's used when they're wanting to bond with a new baby. It provides partial wage replacement through the state. So employees pay into it with taxes, and then they can garner these benefits while they are off work. So in itself, paid family leave is not a leave of absence. A lot of the time someone might be on a protected leave, like CFR leave for baby bonding, and they're drawing their partial wage replacement through this paid family leave program. If the employee themselves is dealing with a medical issue or injury, then it's going to be the SDI, State Disability Insurance Program. Now, there was an old rule that said employers could require employees to burn up to 2 weeks of vacation or PTO before they could use their paid family leave benefit through the state. So someone might come and say, I'd like to go on baby bonding leave. And the employer says, no problem, we've approved that, but you need to use 2 weeks of your vacation before you get paid family leave. That rule has been changed. So as of January 1, 2025, employers are no longer allowed to do that. An employee can begin their paid family leave benefits immediately when they go out on leave. So make sure, if you had this old rule, if you're not sure that you enforced it, take a look at your handbooks, your leave forms, and train your payroll staff on this important change so you don't accidentally force an employee to use their vacation rights, which would go against this new AB 2123. And then finally here, I want to cover CalSavers retirement. You might have heard about this in some of the past years. It's been kind of being phased in based on employer size. But what CalSavers is, it's a retirement savings program for employees in California if their employer does not offer a retirement plan at work. So for any employer that doesn't offer a retirement plan, then there's this option. What the employer has to do, they don't have to pay any fees or pay into this, but if they don't offer a qualified retirement plan, they have to make sure to maintain an employee roster and submit the contributions via a payroll deduction for this retirement program for employees. Participation is voluntary, but employees are automatically opted into the program. They have to choose if they want to opt out, if they don't want any payroll deductions going towards their retirement. So there's administrative components for this for the employer. Now, if you have 5 or more employees, you've already been required to do this if you don't offer a qualified retirement plan, such as a 401k, for example. But now employers with just 1 or more employees are going to have to register. And that deadline is December 31, 2025. So you do have the rest of this year, but basically any employer in California, if you do not offer a retirement plan, qualified retirement plan, you'll have to enroll your employees in CalSavers. So give some thought. Maybe you've been contemplating whether you do want to offer a retirement plan or not. Get some information on that, make an informed decision, and just don't leave it till the last minute because it can be more stressful, right? Having to go and get everything ready for this. All right, so again, we would recommend that you're updating your employee handbook, prepare for that new notice requirement for crime victims, just be on the lookout for that. Update your leave practices in regards to that new paid family leave rule, and then register for CalSavers if needed. And someone asked, and I believe it's related to CalSavers, is this only for salaried employees? And the answer is no, it's for all employees if you don't offer a qualified retirement plan. So it would be all employees. All right, so now we're just going to close out with some health and safety updates. So as I mentioned, last year, the Workplace Violence Prevention Plan requirements went into effect. That was back in July. This was a pretty big watershed change because it applies to almost all California employers that you're required to maintain a written workplace violence prevention plan and also update it each year. So that's really what we're going to call your attention to, because I think for a lot of employers, maybe you scrambled to get this plan together, but then it's easy to forget we actually have to maintain it going forward. There's also annual training requirements for your employees. So what are those ongoing requirements for the workplace violence plan? Well, you're going to want to make sure that you're reviewing that plan at least annually. So as a reminder, CalOSHA has a template that you can customize to put your plan together, but you're going to want to take a look at that and see, did we in the past year have any threats of violence or any violent incidents at our workplace, whether that was employee to employee or maybe a customer threatening someone, or maybe it wasn't a full-blown incident, but it could have resulted in something, right? So take a look and say, is there anything we can change with our practices or policies now that we have that experience to make our workplace safer? What's our emergency response protocol? Also is required to solicit feedback of your employees annually on your plan and on what they think they should be trained on and how to mitigate hazards and report hazards in your workplace. So that's something you're going to want to make sure that you have someone staying on top of, whether you're sending out a survey or holding meetings or sending an email. Give everybody the opportunity to participate in your plan on an annual basis. I would recommend doing that first, seeing what the feedback is, and then I would schedule your annual employee training on your workplace violence plan. So that's another requirement that is annual. It has to be by someone that's knowledgeable in your specific plan, and there are required topics that you have to have in that training. And then throughout the year, scheduling periodic hazard inspections and safety meetings. If you need a bit more help in this area, we do have resources for you, a do-it-yourself package that is available, and Anna's putting a link in the chat to that. And last year was a busy year for CalOSHA with prevention plans. So they also implemented this new indoor heat illness prevention plan requirement. So that's probably the furthest things on our minds right now. We're all chilly here in the winter, but it's an important thing to make sure to get on top of. If this could apply to you, I would put this plan together now, so you're, again, not scrambling later when it does start to heat up. So this went into effect back in July, and it applies to any indoor work area where temperatures reach or exceed 82 degrees while employees are present. So as you can imagine, it was aimed at places like manufacturing warehouses, restaurant kitchens, right? But it's not limited to that. It's any employer. If you don't have, fully functioning AC, for example. Outdoor places of employment have already been required to maintain a written heat illness prevention plan for a number of years. We do have some great fact sheets for CEA members on this. Again, Cal OSHA also has a template for both indoor and outdoor plans if you need to customize this. But at a high level, what the essential requirements include is when you are going to exceed that 82 degrees, we have to provide fresh and suitable drinking water. So that's a responsibility of the employer. Ensuring that we're maintaining a cool down area, so a cool place that employees can go that's shaded to take cool down breaks to reduce the likelihood of a heat illness episode, that we have emergency response procedures in place, and that for any new hires or newly assigned employees that we're monitoring them to make sure they're acclimating to working in the heat. We also have to have that written plan, as I mentioned. We have to train our employees and supervisors on heat illness and how to respond to it. And then there's also some additional high heat requirements if your workplace is going to go over 87 degrees. Maybe you work with boiling water or fire or ovens and it gets very hot in the kitchen, for example. There's going to be some additional requirements, or if your employees are having to wear restrictive clothing. So make sure you get in compliance with that. And then finally, just a reminder on COVID-19. So we do still have Cal OSHA's COVID prevention non-emergency standard in effect, but it's actually expiring soon. So February 3rd, 2025, Cal OSHA's standard is expiring. There's still requirements to hold on to certain records related to COVID for a whole nother year after that. So you don't want to start throwing stuff away and shredding stuff. Make sure you hold on to it to meet those record retention requirements. And then also pay attention to any local requirements that may exceed what the state requires. But we have a little bookmark for you here. You can bookmark Cal OSHA's site. We'll see what they do here. If they, replace it with any sort of general aerosol transmissible disease standard, your guess is as good as mine right now. But so we'll just have to see in another few weeks or so what happens with that. All right, so make sure you get in compliance with those prevention plan requirements. Monitor COVID as we continue. We do have some safety partners that specialize in helping with those types of plans and training for your staff if you need additional resources there. All right, so now we can do our recap, and I'll also monitor the chat box to see if we have any outstanding questions before we close out here. So just some general reminders, make sure you're staying up to date on all of your training requirements. So that includes harassment prevention, annual workplace violence training, and now the recommended supervisor wage and hour training. Make sure you keep your employee handbook up to date with all of the new laws. We can assist with that. Comply with the new wage requirements. And remember, we always want to pay attention to those local ordinances. Make sure you have that compliant labor law posting update, and then stay tuned for some of those mid-year changes that we might have coming. And again, a great way to do that is follow CEA's blog at employers.org, where we post a lot of updates for free for you. Again, I want to give a big thanks to the Alameda County Workforce Development Board for sponsoring this today. I have your hotline number there for you if you do want to give us a call. So again, that's 888-202-5668. And I see Anna has hopped back on, and Darlene, if you have any closing words for us.
No, thank you for being here. There are a couple of questions in the chat. One question is this only for salaried employees?
I believe I addressed that one. If they're referring to Cal Savers, the answer is no, it would be all employees would have a right to participate in that program.
Okay, and the other question I believe was addressed, are you able to share how Cal Savers exempt employees, what they need to do?
So it looks like exempt employers, what they need to do. So if you are, so if you offer a qualified retirement plan, you would go to the Cal Savers website, unless this has changed, but what my memory says is that you would go and just submit something to Cal Savers that certifies that you are an exempt employer. So it's just a one-time kind of click and submit to CalSavers to let them know that.
Thank you. And I believe you mentioned at the beginning, this webinar will be made available. So if anyone would like a copy of that, it will be posted on the Alameda County Workforce Development Board website, and we can make that information available to you. Carmelo and I, we both have our information in the chat. Thank you to CEA for everything that you've provided, all of the information. This is wonderful information that you've shared with us today.
Thank you. Thank you, Darlene. Yeah, so just before we close out here, and someone did put a comment in the chat, which is a very good one. Oh, it was Carmelo. Sorry if I misspoke there. It is the city of Alameda that has their own minimum wage requirement, not the county. So sorry if I spoke too broadly there. So that is accurate. And so just closing out here, if you are interested in CEA membership, we have some different plans available, so you can always reach out to us for more information. We also have an HR Assist program where we can send somebody to do on-site day-to-day HR services for you. And with that, I have our survey QR code here. We would love your feedback, as Anna mentioned, to know how we're doing, and so we can pass that along to Alameda County's Workforce Development Board. And I also have your codes today if you're getting continuing education credit. So I can go ahead and read those now, and then Anna will close us out here. So for HRCI, it is 691119. And for SHRM, it is 25-SPZNA. And Anna also just posted those codes in the chat. All right, Anna, I will kick it back over to you.
Awesome. Thank you, Juliana, for sharing your time and expertise with us today, especially battling a cold. You did it. Thank you, Carmelo, Darlene, Claire, and your entire team behind the scenes for sponsoring today. We do have some pending dates for the rest of the series, so make sure you are still on the Alameda County Workforce Development Board email list. Follow their website to make sure that once we have those dates solidified, that you are able to register and join us live. It looks like it's going to be an amazing lineup, so I really encourage you to register once those dates are confirmed and available. As I mentioned, we do have that survey again. 5 questions, most of them multiple choice. It generally takes people 60 seconds or less to do it. But as you close out of Zoom, a browser window will pop up. All you have to do is click the opt-in button and it'll take you to that survey. So with that, I want to thank you all for joining us live, for bringing your questions. As Darlene said, and as I mentioned at the beginning, this recording will be made available as soon as the video is done processing, and then the Alameda team makes it available on their website. So make sure you are checking for their notification that it is available for playback. And with that, I want to say thank you, everyone. Enjoy the new year, and we'll look forward to seeing you on another training soon. Thank you all.
Thank you, everyone.
Thank you.